hand over you for your talk, which is entitled Jeremy Bentham, the Civil Law and Legal Transparency in Historical and Comparative Perspective. Thank you so much for joining us today, Fred. It's a real pleasure.
Thank you. I'm delighted to do this. As you said, my goal here is to provide a little bit of theoretical, historical, and comparative perspective and background to what you are focused on more concretely and more specifically. And indeed, I was just listening to the last few minutes of the previous session, and I noticed one of the questions that came up, or one of the issues that came up was just why is it that we are concerned about transparency and accessibility? And in large part, that's what I will be addressing. So, as I said, this is a historical and comparative and implicitly theoretical background to the question of the accessibility of law. And historically, I want to talk principally about Jeremy Bentham. So I'm sure you've all heard of Jeremy Bentham as the late 18th century and early 19th century philosopher who is the creator of modern utilitarianism, the greatest good for the greatest number. You may have heard of him as well as a colleague of James Mill, John Stuart Mill, John Austin, Elizabeth Wollstonecraft, and some number of other early 19th century London intellectuals. You may have heard of him in the context of the theory of crime and punishment and the panopticon and his views about effective punishment. Some of you may even have literally seen him. He was not uncomfortable, to put it mildly, with his own place in history. And as a result, his embalmed body, seated in a chair, sits on the ground floor of University College London. I should note, although not of any particular theoretical importance, that if you do see it, the head of Bentham that sits on the embalmed body is actually a reproduction. The head has been preserved. It is taken out and exhibited once a year, but undergraduates being undergraduates, the risks of the actual head being accessible to the public and to undergraduates over the years has unfortunately created problems, but that's Jeremy Bentham. But perhaps less well known are Bentham's views about legal accessibility and legal transparency. So Bentham was one of the world's great haters. He hated more or less everything. But in particular, despite being the son of a lawyer, despite being trained as a lawyer at Lincoln's Inn, Bentham hated the law and hated the legal establishment. And in particular, he hated the common law. So he referred to the common law as dog law. And the reason he referred to the common law as dog law is, he said, that the common law operates in the same way that you train your dog. The dog doesn't know in advance what's good behavior and what's bad behavior. But when the dog does something wrong, then you beat him. I don't advise this as a method of dog training or anything else, but Bentham said the dog only knows what's right and what's wrong because after he does something that's wrong, then he is punished. He has no advance notice of what's right or what's wrong. That, in Bentham's view, was how the common law operated. People don't know in advance what they can do and what they can't do. They engage in some sort of behavior. Then there is litigation. And then after the fact, a judge decides whether the behavior has been lawful or unlawful. So Bentham referred to the common law as dog law. And related to this, Bentham also believed that the common law was unnecessarily complex and inaccessible to ordinary people. Why so? So Bentham believed that judges wanted it that way. They wanted it that way because that would increase their power. If you didn't know what the law was until a judge said what the law was, that would increase the power of judges. Similarly, lawyers wanted it that way. If you couldn't know what the law was without a professional massaging and analysis of volumes and volumes of case law, then you could only know what the law was by going to a lawyer. This would benefit the lawyers. So therefore, Bentham believed that there was a conspiracy. He called it Judge and Company, a conspiracy between lawyers and judges to make the law unnecessarily complex in order to increase the power of judges and the income of lawyers. So this was, for Bentham, embodied in some number of legal devices, among them, for example, the legal fiction. And if you think that I was exaggerating when I described Bentham as one of history's great haters, this is what Bentham said about lawyers and legal fictions. Every criminal uses the weapon he is most practiced in the use of. The bull uses his horns, the tiger his claws, the rattlesnake his fangs, the lawyer his lies. Unlicensed thieves use picklock keys. Licensed thieves use fictions. And at other times, Bentham observed that, and I quote, in English law, fiction is a syphilis which runs in every vein and carries into every part of the system the principle of rottenness. Or the pestilential breath of fiction poisons the sense of every instrument it comes near. So when Bentham was talking about legal fictions, he was not just talking about legal fictions in a somewhat narrower sense. He was talking about legal fictions in the broader sense that of legal language that was technical, legal language that departed from ordinary usage, legal language that could not be understood by the normal, everyday non-lawyer reading the law. So Bentham proposed that it ought to be unlawful to give legal advice for money. I repeat, it ought to be unlawful, illegal to give legal advice for money. Now, we might have thought that he was joking, but there's no indication that Bentham ever joked. In the language of the legal historian Geoffrey Treasure, Bentham was, quote, not gifted with a strong sense of humor. So when he described the law, or when he proposed in an essay called Scotch Reform that it ought to be unlawful to give legal advice for money, he was proposing creating a system of incentives to for Parliament to write law as clearly as possible, to write law as simply as possible so that it could be accessible and understood by ordinary people. Eliminate legal fictions, eliminate technical language, write law in ordinary language. I should mention, for those of you who are familiar with civil law systems, that in many civil law systems, especially the civil law systems of Latin America, Bentham's ideas, not because of Bentham, but Bentham's ideas have a significantly greater presence. So if you find yourself in Santiago, Chile, or Lima, Peru, or Bogota, Colombia, if you go up to an ordinary newsstand, an ordinary news agent, you are able to buy copies of the law in ways that it's surprising, to put it mildly, to find the law so available in the common law world. That in places such as the ones that I have just mentioned, the code will be subdivided into categories that might be useful to ordinary people. The law of corporations, the law of labor and working, the law of traffic, the law of employment in other varieties, the law of housing. And you can go to the newsagent and just buy a copy of the code, and people actually do it, and they consult the code to find out what the law is. This is consistent with a civil law view in which the code, often written in detailed but accessible language, is based on a system in which judges are relatively unimportant players, in which legal arguments can be made and frequently is made by primary reference to the code without regard to whether there have been previous judicial decisions interpreting the code or not. In the civil law, the code is primary, interpretations of the code are secondary, interpretations of the code by judges are not authoritative in ways that they are in the common law. Precedent is relatively unimportant compared to the common law, although this is changing. And in many other respects, the civil law comes closer to Bentham's ideals than does the common law system in which he existed and which he so despised. So all of this is the at least historical and comparative argument for treating law not as a technical language, treating law as being optimally or ideally accessible and transparent. But there is another view. So I don't know whether the coordination will work here, but this would be the perfect time for the quote that I provided to go up on the board. Ah, there it is. Okay. So read this for a moment. This is from the shop manual for a 1961 MGA. And even assuming that people from your country and not from mine know that a bonnet is what Americans call a hood and a spanner is what Americans call a wrench, this, which appears to be in English, is largely inaccessible to ordinary people. Before rebushing the lower trunnion banjos, you must remove the bonnet fascia and undo the A-arm nut with a number 3 spanner. Huh? I put this up there just to suggest that there are domains in which it is important in the service of precision to write in largely technical language that might be largely inaccessible to ordinary people. The author of the 1961 MGA shop manual was not interested in speaking to MGA owners. He was not interested in speaking to the public at large. The author was interested in speaking to trained, experienced, technically competent mechanics. And for trained, experienced, and technically competent mechanics, this was the language that most carefully and most precisely and most accurately explained to them exactly what they were to do. Yes, you could imagine putting this into ordinary language. You could imagine translating this into the language that ordinary people might understand, but it might be too loose. It might not convey the instructions as carefully as necessary. Technical usage with some frequency provides a degree of precision that one does not get in ordinary usage and ordinary language. So when we think about transparency, when we think about accessibility, we must recognize that there are trade-offs involved in making law, in making legal rules and legal regulations and legal requirements immediately available to non-trained, non-technical people. And to some extent, this relates to a common distinction in legal theory, which in my country is often referred to as the distinction between rules and standards. When we distinguish between rules and standards, in large part, what we are distinguishing is clear, precise, technical, detailed rules on the one hand, and broad, vague, loose standards on the other hand. Rules are clear and precise. Standards are broad and vague. But of course, the decision about whether and when to use rules and whether and when to use standards, recognizing, of course, that this is not an either or and that there are gradations, but still the decision of when to write law that's closer to the rules end of this spectrum and when to write law that's closer to the standards end of this spectrum involves a number of somewhat more complex considerations. These complex considerations arise out of the fact that clear, precise rules tend to be very good at providing notice in advance of what can be done and what cannot be done. But they do it at the cost of being particularly inflexible and therefore being particularly bad at accommodating to an uncertain future. H.L.A. Hart, the great English legal theorist of the middle of the 20th century, principally talked about the fact that one of the continuing dilemmas of legal drafting or legal design is that we cannot predict the future. And not only can we not predict what will happen in the future, we cannot predict what we will want to do when we get to this uncertain future. And once we recognize what Hart described as the dual problems of uncertainty of fact and uncertainty of aim, then there are advantages of writing laws in ways that maintain this flexibility. And therefore, there might be times in which it is useful to write laws in terms of standards, loose, vague, open-ended, and therefore not very good at providing notice, but very good at leaving open the possibility of adapting to now unforeseen future circumstances. Very good as well to adapting to the immediate context. Very good at allowing judges or other interpreters to decide what is the best result for a particular case. So it turns out that there was an interesting case study of this distinction between rules and standards in the American state of Montana about 20 years ago. So for those of you who are familiar with or unfamiliar with American geography, Montana is a geographically very large state in the American Northwest. It has a great deal of land and very few people. And 3/4 of the state of Montana exists to the east of the Rocky Mountains and is very flat. So we have largely unpopulated, vast expanses of flat territory, which have some number of roads, and the roads contained, as is normally the case, speed limits. The typical speed limits on Montana roads were 65 to 70 miles per hour. Montana at some point decided that given the variability of conditions, given the relative infrequency of anything that looked like traffic congestion, and so on, it was not really necessary to have numerical speed limits, rules in the rules standard sets. And they eliminated numerical speed limits and decided instead that the only rule would be this: driving must be at speeds that are reasonable and prudent. That experiment lasted for about 5 years. It turned out that people had vastly different ideas of what reasonable and prudent was. Police officers had varying ideas of what counted as reasonable and prudent. Judges had varying ideas of what counted as reasonable and prudent. And this experiment of eliminating numerical speed limits in favor of precise, detailed, but arguably inflexible numerical speed limits was abandoned, and Montana now has numerical speed limits again. So another example of this issue comes from what has now been and has been for the last 30 years or so, a central example in legal theory, in jurisprudence circles. The 1890 American New York state case of Riggs versus Palmer. Francis Palmer was a farmer in far upstate New York near the Canadian border. He had a large farm, and as he got older, he needed assistance on this farm, and the assistance was provided by his grandson, Elmer, who helped out on the farm and did some number of other things for Francis. At some point, recognizing what Elmer had done, or recognizing Elmer's assistance, Francis wrote a will leaving all of his property, including the farm and including a fair amount of money and personal property, to Elmer. But after writing the will, Francis became somewhat disenchanted with Elmer. Elmer was not as diligent as he had been in the past. Elmer engaged in some number of activities, typically or frequently involving alcohol and women, or the combination of the two, that increasingly produced anger in Francis. Elmer perceived this anger, Elmer perceived this dissatisfaction, and Elmer began to worry that Francis was going to change his will and no longer leave the farm and all of the property to Elmer. So Elmer did what all of us would have done in the same circumstances. He poisoned his grandfather. His grandfather died from the poisoning. Elmer was shortly thereafter apprehended, sentenced to a period of imprisonment, a relatively short period of imprisonment, because Elmer was still a minor at the time, under the age of 21. So when Elmer was released from incarceration, he took the position that, yes, he had done something wrong. It was wrong to murder his grandfather. But although he had done something wrong, he was nevertheless entitled, under the exact words of the New York statute, to inherit the farm and inherit all of his grandfather's money. And it turns out that the New York statute of wills provided in considerable detail how money should be transferred, and provided that if a testator wrote a will while of sound mind, then upon the death of the testator, the beneficiary would inherit according to the terms of the will. No exceptions, no qualifications. Elmer claimed this was a nice, clear, detailed law. And although it might have been written without the legislature anticipating at the time that beneficiaries were going to murder the testator, that was a failure in drafting, but nevertheless, the law was clear. So it turns out that there were alternative residuary beneficiaries who challenged the distribution of the property to Elmer the murderer, and it turned out that the alternative beneficiaries won. There are arguments on both sides. The New York Court of Appeals eventually decided the case, although there was a majority view against Elmer and in favor of the residuary beneficiaries. There was a dissenting view that said, this is what the law says. What the law says in its clear, precise form is what ought to be enforced because of the virtues of notice of the law, in the law, virtues of transparency, virtues of accessibility. So the lesson of all of this is that although transparency and accessibility may have obvious advantages, not all laws are written with the ordinary public as the audience. Think again of the MGA shop manual from 1961. Think of various other laws whose primary addressees are not the people whose conduct is to be regulated, but rather the enforcers, the administrators, and so on. In those circumstances, it may be better to write law more technically and less accessibly than in others. That's not to make an argument for one or the other. It is to say that the question of how much transparency we want, how much accessibility we want, is a function partly of what are the consequences and what are the stakes. It is a function of to whom is the law addressed, principally. So if we, just to take a contrast in terms of contemporary American law, the still controversial United States healthcare law, going back to 2010, the Affordable Care Act, is about 2,140 pages. Obviously highly technical, obviously highly inaccessible. I suspect that in many other countries, including yours, the details of national health and the like are similarly embodied in highly detailed statutes, not accessible to the general public, but providing a little bit more notice in advance to administrators and enforcers about what they should do and what they should not do, rather than requiring litigation and judges in every case. By contrast, the American, principal American anti-competition law, the Sherman Antitrust Act of 1890, prohibits contracts, combinations and conspiracies in restraint of trade or commerce. Period. And that's it. Most, therefore, American anti-competition law has been made by judges. Most American anti-competition law is inaccessible to the actual business people who must make decisions that may or may not run afoul of this law. This is just the kind of thing that so angered Jeremy Bentham. You don't know whether what you were going to do is proper or improper until you have done it. Now, over the ensuing 132 years, there have been countless judicial decisions interpreting the 10 or so words that I just listed, but it takes lawyers to interpret what the judges have done. It takes judges to interpret and refine what Congress initially has done, and therefore antitrust law, competition law, has become a lawyer and judge dominated system in ways in which healthcare law has largely become an administrator dominated institution. Again, which we want and when can be a subject of considerable contextual variation. So one final example, if I may bring it back to home in the sense of my own principal discipline. One of the interesting things about the world's constitutions, the formal single document written constitutions of the kind that one finds in every country in the world except the United Kingdom, New Zealand, and Israel, single document written constitutions vary quite considerably in size and detail. Among the shortest are the US Constitution, at about 8,000 words, the Canadian Charter of Rights and Freedoms, even shorter than that. But these constitutions, especially the US one, which dates to 1787, and even the Bill of Rights dates to 1791, and the important 14th Amendment dates to 1868. These are these short constitutions tend to be vague. The US Constitution contains provisions such as due process of law, equal protection of the laws, unreasonable searches and seizures, commerce among the several states, cruel and unusual punishments, all vague phrases requiring judicial interpretation, but also adding a degree of flexibility, enabling the Constitution to persist over time. By contrast, the Constitution of India is several hundred pages. The Constitution of Brazil is 700 pages, several hundred pages. The 1995 post-apartheid Constitution of South Africa, in my version, is 114 pages. All of these relatively modern constitutions believe that in order to provide guidance to the public, provide guidance to everyday officials, many of whom do not have legal training, it is important to write in considerable detail, and at times to write in language that does not need judicial interpretation. So a good example of this comes from equality law. American equality law at the constitutional level is largely a function of judicial interpretation of the phrase, nor shall any state deny to any person the equal protection of the laws. This phrase, which dates to 1868 and the 14th Amendment, leaves it to judges in common law fashion to decide what forms of inequality are unconstitutional and which are not. By contrast, and not surprisingly given the history, the South African equivalent contains detailed designation of the forms of inequality that will inspire constitutional review. Race, religion, color, language, age, sexual orientation, and some number of others, not leaving it to judges to decide which forms of inequalities are unconstitutional, but basically putting this in the text. So I've not attempted to provide any easy answers here. If I have done anything, it is only to complicate the question that I heard at the end of the last session. Why do we have transparency? Why do we have accessibility? My instructions contained in short, easily accessible language were to talk for approximately 30 minutes and then take some number of questions. 30 is a rule and not a standard. So I will take that as my limit of what my prepared remarks, but I would be delighted to entertain questions, comments, personal abuse, or whatever you think is appropriate. Thank you very much for this invitation. I only wish that I could have done it in person.
Thank you. Thank you so much, Frederick, for a fantastic and, fantastic presentation. You may not have given us answers, but you've given us a lot of questions. So I think that Sarah has a question for you. I would assume no, because I could see you. Then I have multiple questions for you. I was fascinated, especially by the end of your presentation when you talked about constitutions. And although I've now gone into intellectual property and legal technology and so on, that's the background I come from. So when you were talking about long and short constitutions and the type of language that is used in constitutions, that triggered lots of interesting questions in my mind. After having spent a couple of years as a student studying the Constitution of Nepal, which is 230 odd pages long, I guess I have a strange question, but I wonder, and it's really a shot in the dark, if you like, we know that we have this distinction between rules and standards, and it's a little bit of a spectrum. It's not a real distinction, so to say. But we also know that within a country, we tend to have laws, so to say, to use the term very broadly, that will provide sometimes more standards and sometimes more rules, if you like. And if we think about constitutions, we will, at least the older constitution will tend to contain more standards and rules, and then laws will contain rules that sort of apply in the context of those standards. But I was wondering, and you've mentioned the fact that things are changing. We are having more long and articulated constitutions that provide more rules and standards, for example, in modern constitution making. But I was wondering, is there like a coefficient of flexibility, if you like, of the laws in a country that always stays the same? So is it to some extent true that if you have, for example, a constitution that contains more standards, that is more oriented towards standards, then you will necessarily have legislation that is more focused on rules? And if you have a constitution that is more focused on rules than standards, then you will not necessarily have the same degree of sort of precision and definition in the legislation itself. Or is this something that doesn't work?
I mean, it's an interesting and plausible hypothesis. I don't know whether it's true or not, but it's certainly plausible. It would suggest, I think reasonably, that any legal culture has a relatively fixed amount of tolerance for vagueness and a relatively fixed amount of preference for precision. And that regardless of where we start and regardless of how we embody it, ultimately the system will gravitate towards this equilibrium that the society thinks is appropriate. I think there's something to that. Indeed, I've seen this in a number of areas of American law. So, for example, I mentioned the Sherman Antitrust Act, which has rather spectacular vagueness in the statute. But when it is interpreted by the Supreme Court has provided some number of what are called per se rules. That is, the Supreme Court adds very precise, detailed, but accessible rules. So it turns out that price fixing between and among competitors is automatically, instantly a violation of the Sherman Act. And various other more technical practices are treated as per se rules. So judges make the vague statutes more precise. Conversely, when statutes contain no exceptions, when statutes are written with an enormous amount of inflexible detail, one of the things that we have discovered, and Riggs versus Palmer might be an example, given how the judges actually decided, is that judges will add judge-made exceptions. Judges will round off the sharp edges of precise statutes, such that eventually we wind up with that equilibrium between vague standards and precise rules that the society in the large thinks it's appropriate, regardless of where we start. In a way, that's gratifying, but in a way, it's depressing because it suggests that there is a limited amount of control that the actual rule drafters are going to have. If they draft too precisely, the judges will take away some of that precision. If they draft too broadly, judges may add precision, even if it was designed to make it somewhat more flexible. I should mention, given what you described as your own field, that this is an area in which in the US, and I assume everywhere else, modern information technology is creating just these kinds of problems. So the American First Amendment, Congress shall make no law abridging the freedom of speech or of the press, was, to put it mildly, drafted in technologically simpler times. There was no internet, nor radio, nor television, nor social media, nor any of this. So how we should deal with modern information technology and its potential and problems turns out to be one of the big American First Amendment debates of modern times. We see it in other areas. The US Constitution gives Congress the power to create a system of patenting new inventions. But 20 years ago, there was someone desired a patent for essentially a clone of life. That is a clone of a living organism. That would have been thought inconceivable in 1787. How do we deal with this? So the problems are still with us. Technology may be making the problems even greater.
Thank you. Thank you very much. Let me see if I can see everyone, if there are questions in the room for you. I'm sure there will be some questions that will come from the room, but I'll take silence as my chance to ask.
It's Bridget. I couldn't see where to ask the question, so I just thought I'd just chip in.
Please.
Is that all right? Yeah.
Yeah.
No, it's just this comment on the tension between flexibility, very prescriptive rules, and constitutions that are much more sort of principle based. And I'm thinking of sort of in my world, that's, I'm writing very prescriptive social security rules, but all the time there's a Human Rights Act in the background, and at any time the judge could come in and say, well, these rules are in conflict with the Human Rights Act, and you're never quite sure, what the result of that would be. But I guess that's how the tension plays out in the real world. You can guess, and one of my jobs as a lawyer working for the government is that you're familiar with the case law, and so when there's a new policy, you might say, well, actually we think that would be challenged. We don't think we'll get away with that. And so the two things, so you have these very prescriptive rules, but you also have these high level principles, and the two do complement each other. I think it can be a bit, can be difficult when you get litigation, but I think on the whole it sort of works quite well.
But I think,
yeah.
But Jeremy Bentham would have said it works quite well for the lawyers, it works quite well for the judges, it works quite well for the officials. But what if you were a Social Security beneficiary or a possible Social Security beneficiary? Can you go to a newsagent, buy the Social Security law, and look it up and see what you are entitled to and what you are not?
Yes, totally. Yes. Well, you can go online and look up legislation.gov.uk. And in fact, if you Google, universal credit regulations, they'll just come up, and there they are. So the rules themselves are out there if people want to read them. But if
the rules remain subject to judicial determination about consistency or inconsistency with the Human Rights Act and so on, then it may be that the rules themselves are only part of what the law is, and whether that's a good or a bad thing will vary with what kind of laws we are talking about. But I think at least one side of the conflict that I've tried to describe would say that if you can't, if an ordinary person, ordinary Social Security beneficiary can't be sure of what the law is without having someone explain what judges are likely to do, then that would be a problem. The other side would say, yes, but judges have the ability to recognize contexts and situations that ordinary people might not see, and that judges can provide useful flexibility in all of this. Again, I repeat, I don't have any quick answers to this, but as you suggest, as soon as judges come into the picture, a degree of certainty and predictability gets sacrificed in the service of flexibility. And when we want more of one and when we want more of another remains perhaps the greatest issue facing us.
I think that tension will always be there, and I think it's especially for, you know, that uncertainty might not be good for the people who are subject to the law, the claimants, but they're also not good for people who are having to write computerized systems. As the judges come along and say, well, that's wrong, then you've got a real problem. So yeah, it's a tension always. Yeah.
Sorry, jumping on this, do you think there are ways in which technology will be able to help? Because I mean, we heard from Luke and Bridget earlier about how we can potentially use computers to sort of model the law and understand how it will affect users ultimately. Would this be a new way of helping citizens, for example, understand what the law is, but also to understand the context that surrounds the law, and so the law in which, the way in which the law will actually be applied, not just the letter of the statute, if you like?
I think the answer is yes, but that's the answer of someone relatively ignorant about the technology. But from what I know, at least modern attempts to model legal reasoning, and especially to model legal reasoning in a common law or case law system, have tried to put multiple judicial decisions into an algorithm, such that rather than just randomly look for some judicial decisions rather than others, good algorithms can say, we have seen over X number of years and X squared number of cases the following different decisions, and here are the patterns that can be gleaned from the patterns. And even though judges might be involved, we can predict what judges are most likely to do. So I think that ultimately the common law and a judge-centered common law system, as we've been historically most familiar with it, is rather messy. It may be messier in my 51 jurisdiction country than it is in yours, but it is particularly messy as search techniques for case law become more and more sophisticated. As algorithms become more and more sophisticated, it may be that we have reduced, that we at least can reduce the messiness of the common law, which holds out the promise of keeping judges in the system to deal with necessary exceptions while achieving a degree of flexibility that the classic that a civil law model might not have had.
Thank you very much. Let us see if there's any, is there a final question before we let Fred go. No. I'll ask a final question. Sorry, I thoroughly enjoyed everything you've discussed with us today. But that example about Montana kind of stuck with me, the numerical speed limits, possibly because I've always wondered what the speed limits are in Germany, for example, and they appear to be out of fairness, which is kind of a complicated concept. So we were talking, without going too deep into the technology, but I was wondering, do you see a future where legislation will contain more and more sort of variables or parameters that are that will be determined by computers or potentially by algorithms and other forms? Because one possibility for the future in a case like Montana would be to have, to eliminate the medical speed limits, but sort of introduce variable speed limits that are determined by an algorithm, for example, on the basis of the weather, on the basis of the traffic on the road, all these sorts of elements that a computer is able to collect and potentially take into account. So I wondered if, we heard about this concept of rules as code, but I wondered if we're going towards a future where we may have rules with some code, and whether that could be a way to introduce more flexibility into laws in the future.
I think that's possible. I will leave to others, the futurists, to determine how possible it is. But I should mention that even the system that you've just described may sacrifice a fair amount of predictability unless there's some way of letting the people who are sitting in the car behind the wheel know what the result of that algorithm will be. That is, the weather is variable, the amount of traffic is variable. There are all sorts of things that can go into an algorithm that would enable the algorithm to determine ex post whether the driving was safe or not, but may not enable the driver ex ante to determine what speed at which she or he should be driving at. So I think we are heading in that direction, but there may be limits.
Fantastic. Let us give you a very, very, very big thank you for the time you've dedicated to us, for all the questions you've raised for us, and for all your brilliant answers. Thank you so much. It's been a real pleasure to have you.
And thank you for the opportunity. I look forward to meeting some or all of you in person at some point in the future. Thank you again.
Face to face, yes. Thank you very much. Thank you. So